Capital Forum interview series. My name's Joe Tipograph, and we're delighted to have Mike Knight from the powerhouse law firm of Jones Day here with us today. Before he was with Jones Day, Mike was the head of the FTC's Mergers 2 shop. Mike, thanks for being here.
Well, thanks for having me.
All right, let's just dive right in. Mike, I want to talk about what we see going on right now in the antitrust world, especially with respect to mergers and the transition we've seen from the agencies going from doing structural arguments regarding market share towards a more storytelling approach by looking at competitive effects. What are you seeing?
Sure. I think we've definitely seen a move toward more of a storytelling approach. Certainly, it's been more richer stories, I should say. But I think it's fair to point out that this approach of getting beyond just structure really goes back quite a ways. If you go back to the 1984 merger guidelines, they contain the statement that structural presumptions are really only the start of the analysis. And I think the agencies have been doing that quite a bit. I think over the years, the models have become substantially more complex, and the data to plug into those models has become much richer than used to exist. And as a result, antitrust has become more complex, and I think that's reflected in the 2010 merger guidelines that the FTC and Justice Department put out.
Right. And do you think that this change has been advantageous to the agencies or to merging parties?
You know, I think it's been good for antitrust generally. And now, with that, there's a caveat. But let's talk about the good first. I do think that qualitatively decision making is better than it was when we were thinking more purely about structure. And I certainly think that, again, with the data available now and more complex models, we can get at more qualitative decision making, which is ultimately good for both sides. It's good for the antitrust agencies and it's good for private business as well. I do think there is something to be careful about in that, and that is with the additional complexity of the new models, with the availability of such rich data, it also opens up the possibility of misuse. That and I'm not saying intentional misuse here, but that data and models can be applied in the wrong circumstances to get bad results.
So the market structure approach is very much predicated on assumptions. The assumption that if you have a concentrated market and there's a significant increase in concentration, that it really enables parties to exert market power. Now, as we move towards a more competitive effects approach, what new assumptions do you see being made that concern you?
Well, first thing certainly is structure still remains the starting point. I think despite all that has been written, if you speak with the average antitrust enforcer or the average private practitioner, they will tell you that the analysis begins with identifying the relevant market and trying to determine the structure. I think that the agencies, particularly in the 2010 merger guidelines, have explained both to private practitioners as well as to, I think, the courts, which is an intended audience there, that the modeling is much more complex than that, and as a result, I think that they are essentially putting the world on notice that they have a lot of tools in their arsenal. And I think again, while I think that is very useful and ultimately leads to better decisions, I think that use of those tools without a lot of structure can sometimes lead to problems.
Now, you said that they're talking to the courts in part, but what role does the merger guidelines play in informing judicial doctrine?
Sure. One of the issues that the agencies faced or have faced on occasion in the past is that their analysis, as I said, going back to the 1980s, began to become more complex. So they have a complex analysis, but they had guidelines that were relatively simply structured. They would then take their cases to court, and sometimes they would have a judge looking at the agency guidelines and saying that the agency's case didn't appear to follow the relatively simple layout of the merger guidelines. So I think the 2010 guidelines were in part to show courts that the actual analysis performed by the agencies is more complex than one might have believed by just reading the old guidelines.
But the law still says that market definition has to be proven. Is that something that you see possibly changing over time?
I think that market definition is always going to be a fundamental part of most antitrust cases. I do think that where you'll see a change and where you're starting to see a change is the willingness, certainly on the part of the antitrust enforcement agencies and possibly eventually on the part of the courts, to see harm first and then back into the market structure and market definition from there. Sometimes in identifying a relevant market, you can start where you think you see harm and build a market around that.
Okay, so for example, in Section 2 jurisprudence, there's the possibility that you can have direct evidence of monopoly power, where there's an alternative circumstantial approach where you can look at the market structure. Do you think that it may go that far in merger analysis?
It probably depends on the harm, quite frankly. I think that if you have what appears to be very clear consumer harm from particular conduct, and it looks like monopolization, then you may be able to back from there and figure out what the relevant market is and test it that way to see if that relevant market makes sense.
Okay. Now, how do we see this playing out in the way that DOJ enforces? I know that we've seen recently with H&R Block, AT&T, T-Mobile, and the AB InBev Grupo Modelo deal, lots of executives' emails and internal correspondence showing up in the complaint. Is this a response to this trend? Is there any ongoing trends that you see between the two?
The use of documents is certainly alive and well, but I will say that it's documents have always been very important to antitrust cases. I think even as far back as the 70s and 80s, I think that having good documents for the agency's case or bad documents for the party's case was an essential part to most enforcement actions. Very few cases were purely brought on structure. I think the agencies continue to be comfortable using those documents, and I think they will do so going forward. I think as you mentioned, we've seen quite a bit of that. I do think there is again a potential danger in using documents that the agencies and courts need to be aware of, and that is that documents often themselves reflect opinions, and the author may or may not be an expert and capable of offering opinion-based evidence. So sometimes documents can be misused. It may be another way of saying this is that just because someone at a company wrote it down doesn't mean it's accurate.
Well, how then are courts supposed to determine what is accurate?
Well, I think they certainly look at documents. They also look at econometric evidence. They look at economic modeling. They look at consumer testimony sometimes. They look at past occurrences of similar conduct. All of those are the kinds of things courts can use to evaluate the predictive impact in the case of a merger of competitive effects.
But when you talk about econometrics, you really have two sides with two very well-established economists that have models that can say very different things. When it comes down to them challenging each other's assumptions, what role do documents play in perhaps supporting or refuting some of the assumptions?
Well, certainly I think that having documents that support the basic underlying premises, the assumptions that go into a model is tremendously helpful. I think if I develop a model to explain behavior and that the assumptions that I use in putting that model together are wildly inconsistent with what the business people are saying in their contemporaneous documents, that ought to be a red flag. On the other hand, if my assumptions are supported by the documentary evidence and I think very importantly the data and past experience, then I think courts will be more willing to accept that model.
Do you think that some of this has been a response to Twombly, which is heightened pleading standards for plaintiffs and enforcers bringing actions?
I do think so in general. However, I would say that certainly at the agency level, this is more about trying to get a more qualitative set of decisions than it is about concern over litigation. I think in the private realm, private lawsuit realm, Twombly plays certainly in any litigation, Twombly plays an important part of where and how you put your case together and what evidence you use and how you plead it and whether it makes economic sense in putting together your basic pleadings. But I think the agencies were probably operating well above the Twombly standard in most cases anyway.
So, Mike, the Section 7 of the Clayton Act is the law that regulates mergers, and it It basically prohibits mergers that the effect is substantially to lessen competition. But we currently use the consumer welfare standard. What is the consumer welfare standard? Is it the same as competition? What should it mean? And how should we decide when a merger is competitive or good or bad for competition?
Sure. The nutshell version of the consumer welfare standard, with apologies to my economist friends, is that if a merger or conduct promotes consumers' welfare, if it's good for consumers, then it's pro-competitive or it's legal. Or should be legal if you adopt a pure consumer welfare standard. So anything that makes consumers richer is a good thing, as opposed to, say, what I would call a societal welfare standard, which tends to say producers and consumers are both members of society, so whatever makes the overall societal pie bigger is the right way to go.
Okay, and is that the standard you think is the appropriate one to be used in antitrust law?
Yeah, I may be in the minority, but I believe that a societal welfare standard is the appropriate reach of the antitrust laws. Having said that, I think it's important to point out that I think in the vast majority of instances those two standards are the same. Ultimately, what's good for consumers usually does maximize societal wealth, but not always.
Right, but I mean, if we're talking about maximizing producer wealth, the whole point of antitrust laws is that when producers are trying to maximize their own wealth, that's when consumers lose. So how are we going to be focused on promoting competition when benefiting when encouraging profit maximizing behavior by the companies has the risk of harming consumers?
Sure. So a pure societal wealth maximization standard looks at antitrust this way. It says we don't care as much about what producers make and what consumers make. What we care about is are resources efficiently allocated. Most times when producers artificially raise price above competitive levels, that leads to an inefficient allocation of resources. So it harms consumers, yes, but it also is an inefficient allocation of societal resources. And as a result of that, it's a bad thing. We ought to prevent it. But I'll give you an example of where there can be a difference. In monopsony cases in which purchasers, in this case consumers, are so strong that they are able to drive price below competitive levels. That also would lead to an inefficient allocation of resources. And yet that's very good for the consumers. The people who are doing the buying pay less. But resources are not entirely properly allocated.
So divestiture policy, when a merger comes through and there's a deal cut to separate production assets and distribution assets so that consumers in a certain market aren't harmed by the competition, the consolidation which might otherwise occur, that's very consumer focused. It's not supplier focused because it's about what assets are used to serve what market. But should antitrust remedies be changed to be more looking up and down the supply chain?
I think antitrust remedies ought to be tailored to restoring a market to a competitive state if it otherwise would be less competitive. And generally speaking, again, that's going to be the same under a consumer welfare standard or under a societal wealth maximization standard. But the remedies ought to be relatively narrowly tailored to try to ensure that competition is not unduly diminished. And those remedies can take different forms, but I think they ought to be it ought to be clear in imposing a remedy that we're imposing the right remedy.
Okay. Now, the societal welfare standard that you're talking about, that was first introduced, many credit the Chicago School for introducing it, and I understand you went to George Mason Law School where
Sure.
And that's where past FTC Chairman Tim Uris and current FTC Commissioners Josh Wright and Maureen Olhausen went. Is the Chicago School reemerging as sort of a George Mason school of antitrust?
That's an interesting question. I think the Chicago School, as it's called, I think has been somewhat revived in recent years, and you could probably point to some of the work of people at George Mason. But I would not call it a George Mason school, put it that way. I think that if there is such a thing, it really, at George Mason, it really is more of what I would call an approach rather than a school. And I think if I had to define it, it is along the lines of the evidence-based approach that now Commissioner Josh Wright has written about. There's a 2011 article in the Antitrust Law Journal that I would commend to anyone, as well as a recent speech that he's given since coming to the Commission, in which he identifies this evidence-based approach and really says we need to get away from labeling things as schools, because often labeling things as a school can lead to choice of the incorrect model to apply in a given circumstance. Instead, we ought to be focused more on testing the proposed models against empirical evidence, against past behavior, against the market as we know it to exist, based on the best available evidence, to make sure that we're choosing the right model. So not choosing a model because it came from a certain school or not, but really trying to identify which model best illustrates what's actually happening in the industry, and that ought to be the focus of the enforcement agencies, and it ought to be the focus of the courts. And so that evidence-based approach, I might call that a George Mason approach, although I'm sure there are others who have espoused it in one form or another. But certainly my experience working at the FTC with Chairman Muris and Chairman Kovacic, who was back in the day a George Mason professor, and certainly my knowledge of Commissioner Wright, I think they all fall in line with that general approach.
Okay, but when we talk about empirical evidence, when we have these new emerging markets in this, the technology that's been coming out, what happens when that evidence just doesn't exist? Do we risk harming consumers because we don't necessarily have the experience, even though the economic models might suggest that there is a very real chance of harm that can ensue?
Well, that's always one of the most difficult questions that face enforcement agencies. I think part of what I'll call the evidence-based approach here, with full credit to Commissioner Wright, is recognizing that enforcement decisions themselves carry risk and potential costs, and that the agencies ought to and courts ought to recognize that those costs exist, and where possible, try to develop rules to minimize those costs. Try to enforce with the idea of minimizing the cost of enforcement, the risk of enforcement, which is really the risk of making the wrong decision. As you point out, that's not always easy to do, particularly in, say, a merger setting where you're making a prediction about the future, and it's not always going to be an easy call to make. I think Commissioner Wright and others would probably say we ought to be reasonably confident that we're getting the right answer before we enforce.
But they'll use the word enforce, which is exactly what these agencies are. They're enforcers. They're not regulators, and they're not necessarily adjudicators either. That's why we have the courts. When we entrust these agencies with protecting consumers, wouldn't it behoove these agencies to be more aggressive and let the courts decide what's right and wrong?
That's an interesting approach. You could have a system in which the agencies were simply prosecutors, and their job was to try to push as many cases as possible and let the courts settle the disputes. I think the system that we have, however, is one in which both federal enforcement agencies have enormous power to bring cases. Very few cases actually make it to court to get litigated. And with that power comes a responsibility that I think the agencies have taken quite seriously to try to get the right answer, to try to enforce when it makes sense to enforce, but they recognize that there's a cost to enforcing when they shouldn't. And I think the debate at the agencies over the past at least 30 years that I've witnessed it has been around how to minimize that error, when to get it right and when to back off, how to get it right, I should say, and when to go forward and when to back off. And so I think that's always the right question. I think that's always the question the agencies are struggling with.
Now, Mike, very recently, your firm had very exciting news. You won a Global Competition Review Award for the work you did in the Hertz Dollar Thrifty merger. Congratulations.
Thank you very much.
Tell me a little bit about what this award means to you and what it means about the merger.
Sure. We're obviously delighted to receive the award. Certainly, the merger was a lengthy and complicated process, one that we ultimately were able to get through, working very closely with the agency staff. And with a remedy that I think the agency was able to get behind, that allowed the transaction to go through, but created a remedy to ensure there wouldn't be any competitive harm. And ultimately, I think we were able to get everything done. Again, a lengthy bout, but I think we were able to get everything done. And for the client, I think it's been good news to be able to get the deal closed.
I think that a testament to this award is that you took a merger that raised very interesting questions about what, we should and shouldn't have in mergers and what we want our mergers to accomplish. And, of course, as party counsel, your job is to present one side, and the other side is the Federal Trade Commission is seeking to question the assumptions that might be made about what the merger could do in this predictive exercise we have of merger enforcement. So I'm curious because, out there right now, we see that there are many brands in the rental car industry. But when you, especially as a result of this merger, look at it, now a lot of these brands have come under common ownership. Now that we have Hertz, Dollar, and Thrifty under one roof, we've got Avis that also owns Budget, and we have Enterprise that owns National and Alamo. So consumers may walk around and see a lot of rental car brands, but this industry is getting to a point where it's very consolidated, and there's three major players. Shouldn't we be concerned that this is going to harm consumers?
Well, I think you have to look at the car rental market just as you would in any merger. Look at the market that's affected, and I think we have lots of industries that are concentrated by traditional measures but seem to operate quite competitively. And I think the car rental industry is exactly one of those. I think the reason that you see multiple brands within the same company speaks precisely to how the business operates, the fact that branding is very important. So Hertz, for instance, is a premium brand, and it was very difficult for Hertz to attract business in the value segment of renters with its premium brand. It offered a lot of bells and whistles with that premium brand, or offers, I should say, with that premium brand, but those come at a cost. So for the value-conscious consumer who wasn't as interested in getting the premium features, wanted to pay less, Hertz wasn't a particularly great option. Dollar Thrifty, on the other hand, gives Hertz the ability to really compete in that space. So I think even though the industry is concentrated in the sense of three substantial players, those brands compete, as they always have, at different levels of the market. In addition, I think it's really important to point out that you do have fairly significant competition from not only regional players, but recent entrants. Sixt, one of the largest rental car companies in Europe, and I believe the largest in Germany, recently entered the United States and has a handful of locations open now, started in Florida and have begun to spread. And regional players such as Fox out on the West Coast have expanded east. So I think you're starting to see movement in that industry as well, which is, it's a good thing to observe the dynamicism of markets.
But at the airports, which is one of the places that we're concerned here, and I think was a primary concern of the Federal Trade Commission, there's not an abundance of space in the airports, especially in these rental car kiosks. In many instances, these brands that we've just sort of discussed, that I've discussed, are closing out any of the access ability for new competition to come in. Isn't that the case?
Well, there's sort of two ways to look at that. One, I think it's important to note that most major airports either have or are in the process of moving to consolidated rental car facilities. If you've ever been to the airport in San Francisco, for instance, you take a tram to a substantial size facility with a lot of rental desks. And those facilities where they come up tend to create all sorts of opportunity for small players to get into the market where maybe they weren't before. In fact, in a lot of instances, it's actually required that a certain number of the slots be given to smaller businesses. And that allows them to play and play on an equal footing with the big guys because their counter is right next to one of the big guys. And I could tell you a story that will take too long, but I recently had the opportunity to use one of these smaller guys at the Atlanta airport and was quite pleased with the result. But that's, I think, an important trend. In addition, however, I think there are lots of ways, even outside of the airport terminal, for companies to serve airport passengers. For instance, here at Washington National Airport, Dollar and Thrifty don't currently operate on the airport. They have a location right across the street that you take a shuttle bus to. Now, you may say, well, gee, why would you want to take a shuttle bus when you could walk to the other counter? Well, it turns out that the rental car counters at Washington National are pretty far away, and in fact, many people take a shuttle to them anyway. So you're just taking a shuttle to a slightly different location. So each airport, the bottom line here is each airport has to be looked at individually. You have to look at the competitive situation there. You have to identify whether you think there's really a problem. I think finally, and probably most important, is fundamentally what our data turned up in looking at this was that pricing is incredibly competitive in this business and has been throughout its history, even as we've seen consolidation to fewer operators but with multiple brands.
But it is competitive, perhaps. But we also heard the head of Mergers One Shop discuss on a recent ABA call that there were documents suggesting that a lot of these operators look at each other's pricing to determine how they will set their own. When we're talking about this, we see that Hertz and Avis price very similarly, but Avis's low-end subsidiary Budget and Dollar Thrifty do not always price as similarly. Is there a concern, with Dollar Thrifty pricing lower, is there a concern, and did the Federal Trade Commission have concerns that Hertz could be bringing Dollar Thrifty's prices up to the same level as Budget as a result?
I think that it's a multi-part question, so let me take it in a couple of swipes here. First, I think it's important to understand that observing someone else's price and setting your own is just as consistent with competitive behavior. Companies do this all the time. They're trying to decide where to position their product, so they look to see what their competitors are doing and price accordingly. It's particularly the case in a differentiated products industry such as rental cars, where it's important to put your product in the proper niche, in the niche where you think it is going to be most effective, where it's going to reach most consumers. So you want to know that you're positioning your product properly. So I think the price observation material is not all that concerning. I think it's also true that, if I was on the same call that you're referring to, I think the head of Mergers One also indicated that they did not have significant evidence of any actual coordination or sustained coordination in the industry. And I think that's incredibly important to understanding that competition here is alive and well. So I think that those facts certainly bore into the analysis. And I also think that if you look at how difficult pricing, how complex, I should say, pricing is in this industry, with rates changing all the time in response to a lot of factors, it would be extraordinarily difficult for even a few players to actually coordinate with any success.
Now, this merger went through a very long, drawn-out process. Can you briefly go through what lessons have we learned as a result of this when it comes to negotiating with the agencies and dealing with the procedural issues that come up with a lengthy review? Sure.
Well, you're absolutely right. This merger was a long haul. That was not entirely due to the regulatory review. It had a lot to do with the fact that we had competing bids on the table at different times, and iterations of the deal in which Hertz was originally the buyer, and then its deal was rejected by the shareholders, and Avis stepped forward as a possible buyer, and then ultimately Hertz rejoined the fray, as it were. So that led to a lot of the length. I think whenever you're in a lengthy investigation, on the positive side, it means that the agency has plenty of time to actually understand and analyze the industry and the data, as do the parties, and so the arguments probably become more and more rich, I should say. And so I think that's probably ultimately a good thing for good decision making. I think that on the downside, obviously, it's difficult to have a client under investigation or participating in an investigation for that length of time. It costs a lot of time and effort and money and distraction from the normal everyday job of running the business.
Well, great. That is all the time we have today. Thank you, Mike, for joining us. It's been a pleasure. And thank you for joining our Capital Forum interview series with Mike Knight.
Thank you for having me.